Good morning and welcome. In the matter of the application of Atmos Energy Corporation for adjustment of its natural gas rates in the state of Kansas, docket number 23 ATMG 359 RTS, I call this hearing to order. This hearing will address the unanimous settlement filed on February 21st, 2023. This hearing is also being broadcast live on YouTube and will be available for later viewing. Okay, let's get started, folks. May I have the entry of appearance, please? Atmos.
Good morning, Your Honor. James G. Flaherty, Ottawa, Kansas, appearing on behalf of the applicant, Atmos Energy Corporation.
Thank you. Wood River.
Yes, appearing for Wood River as outside counsel, Alex Goldberg, and also appearing on behalf of Wood River, Jeff Austin.
Correct. Jeff Austin, my bar number is 13575 from Overland Park, Kansas.
Very good. Thank you. Herb.
Good morning, Commissioners. Joseph Astrab on behalf of the Citizens Utility Ratepayer Board, or CURB. Along with me today are Consumer Counsel David Nickel and Attorney Todd Love.
Very good. Thank you. And KCC staff.
Good morning, Commissioner. Thomas J. Connors and Walker Hendricks appear on behalf of Commission staff.
Good morning. Very good. Does staff have a recommendation regarding notice? Any takers on that? There we go, Thomas.
Yes, Chairwoman. We believe that notice has been accomplished in this case.
Okay, are there any objections? Hearing none, I find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. At this time, I would like to introduce myself and the other commissioners. I'm Susan Duffy. I'm serving as chair of the commission, and with me is Commissioner Keene and Commissioner French. Very good. There are some other preliminary matters. First, we are finding that Zoom works well for this type of hearing. We're able to gather a lot of folks together, and a lot more are able to, through our YouTube channel, watch the hearing. So with that comes a few challenges sometimes. First, if any party does encounter technical issues, ask to go off the record so we can resolve the technical issue. Second, witnesses participating by Zoom are asked to keep their microphones off until the time they are called to testify, at which point they will be also asked to turn their cameras on. Third, if the commission needs to deliberate, we'll be going off the record, entering our Zoom breakout room where you can't hear us or see us, and then we will return. Fourth, since we're participating at a distance, be especially careful to identify exactly what you're referring to when discussing pre-filed testimony and exhibits. We have copies of all that on hand, so we should be able to follow along if you identify it. And fifth, this is a little unusual. There is supposed to be a statewide tornado drill at 10 a.m. Don't be alarmed if you hear the sirens in the background. The hearing will proceed as scheduled, and the KCC will have their own tornado drill later on this month during Tornado Awareness Month. All right. I think that's everything. Good morning, Walker. I see you've joined us. You're on mute. There we go.
Yeah, I apologize. I got on the wrong link, so my delay was somewhat confusing for me because I thought I was in queue and I wasn't. So I apologize.
That's all right. Okay. Will you be participating today?
Yes, both Tom and I will be involved.
Okay, very good. Thank you. Are there any other preliminary matters? For example, is there a motion to admit pre-filed testimony?
Yes, Your Honor. This is Jim Flaherty. on behalf of Atmos Energy. All the parties have agreed that all of the pre-filed direct, cross-answering, rebuttal, testimony that was, and exhibits and schedules that were submitted into the record be referred into the record. And all the parties have agreed to waive cross-examination of those witnesses. So I would ask that the commission refer all of the testimony, schedules, and exhibits into the record.
Very good. Do I hear any objections? Hearing none. They are admitted. Thank you. Okay, so we are going to begin. We'll begin with Atmos's opening statement, followed by Wood River, Curb, and staff, and you've all agreed to a time as well. So, Mr. Flaherty, the floor is yours.
Thank you, Your Honor. And I think Michelle was nice enough to take care of my PowerPoint slides. So I'll ask her to put those up and we'll run through those with you. And Michelle, if you can turn to the next slide, please. Good morning. The purpose of today's hearing is to submit the unanimous settlement agreement to the commission for its review and approval. And what I would like to do in my opening statement is walk through each of the primary terms of the settlement agreement. However, before I do that, I would like to make a comment about the success of the public hearing that was conducted in the rate case. If the commission will recall, the public hearing held in this case was back on January 11th of 2023. It turned out to be the highest viewed public hearing since the commission has conducted such hearings on its YouTube channel with over 1,000 views. That success can be contributed, at least in my opinion, because of the notice changes recommended by Linda Berry and her group. And I believe that at least one of those changes recommended by Chair Duffy, that we move away from publishing the notice of the public hearing in the newspaper and instead use that money to send out an extra notice to each customer and multiple electronic notices to those customers who have provided the utility with their electronic contact information. I believe that it was that change in the way notice was provided that had to do with the good turnout at the public hearing and something that should be considered being used in future rate cases. Michelle, you can turn to slide 3, please. So the settlement agreement before you was filed by staff, Curb, Wood River, and Atmos Energy on February 21st, 2023. It was agreed to by all the parties. The settlement addresses all outstanding disputed issues raised in the pre-filed testimony. Staff, Curb, and Atmos Energy this morning will be presenting testimony in support of that settlement. William Matthews, who is the manager of rates and regulatory affairs for Atmos Energy and who participated in the settlement conference, will be testifying on behalf of Atmos Energy this morning in support of the settlement. Michelle, if you could skip to slide 5, please. Slide 5 lists the primary issues addressed in the settlement and those issues where it was necessary for the parties to provide details and or specific numbers that were agreed to by the parties, either to set rates in this proceeding or to provide necessary information for filings between now and the utility's next rate case decision. Slide 6, please. The first issue related to a settlement on the annual increase to the revenue requirement and the rebasing of the gas system reliability surcharge, or GSRS as it's referred to. The parties agreed upon an annual increase to the revenue requirement of $5.72 million. GSR revenues in the amount of $3.52 million are included in the $5.72 million increase to the revenue requirement. Since the GSR revenues in the amount of $3.52 million will be recovered in base rates when the new rates out of this rate case become effective, the GSR surcharge in the GSR tariff will be reset to zero. Because customers are already paying the annual $3.52 million in GSRS revenues through the GSRS surcharge, the annual net revenue increase under the settlement is $2.2 million. As indicated in Mr. Matthews' testimony in support of the settlement, the agreed upon net annual revenue increase will result in an average increase of $1.03 on the monthly bill of a typical residential customer, which is an increase of 1.2%. Slide 7, please. This chart on slide 7 shows the comparison of the revenue requirement recommendations made by Atmos Energy, staff, and CURB in this case, with the agreed upon revenue requirement included in the settlement. Column 1 shows each party and what was agreed to by all the parties. Column 2 shows a comparison of the base revenue requirement recommended by each of the 3 parties and the base revenue requirement agreed to by the parties. Column 3 shows the amount of the GSR revenues moved to base rates, in which everybody agreed on that amount. And column 4 shows the annual net revenue increase recommended by each of the 3 parties, and then the annual net revenue increase agreed to by the parties. As shown in the pre-filed testimony that has been referred into the record in this case, the main differences between Atmos Energy's recommendation on the annual net revenue increase of $8.31 million and the annual net revenue increase recommended by staff and CURB came down to just a few issues. The difference relating to the return on equity recommendation, for example, made up about $3.8 million of the difference between Atmos Energy's recommendation and staff and CURB's recommendation. And then the difference relating to the amortization period that was used for state EDIT made up about $1.4 million of that $6.3 million difference between the parties. Slide 8, please. You can see in reviewing the various recommendations on slide 7 that the revenue requirement agreed to by the parties falls within the low end of the various recommendations. When combined with the pre-filed testimony and schedules presented by all of the experts in this case, and taking into account the risk and costs associated with litigating the various issues raised by the parties, the revenue requirement agreed to by the parties is reasonable and should be approved by the commission. Slide 9, please. Issue 2, depreciation rates. This is one of those issues where it was necessary for the parties to spell out what they agreed to in the settlement. The depreciation rates proposed by staff for Atmos Energy's shared service assets were agreed to by the parties. The depreciation rates proposed by Atmos Energy for Atmos Energy's Colorado and Kansas shared service assets were agreed to by the parties. The agreed to depreciation rates are set forth in Appendix A to the settlement. And by agreeing to the depreciation rates, the parties indicated in the settlement that they were not agreeing to any policy recommendations relating to depreciation. Slide 10, please. Issue 3 addresses the pre-tax rate of return that will be applied in future GSRS and SIP or SIP filings. The parties could not reach agreement on a return on equity. The agreement, therefore, does not include an agreement upon return on equity. However, the parties did agree upon a pre-tax rate of return of 8.7% that will be applied to future GSRS and System Integrity Plan or SIP filings made by Atmos Energy between this rate case decision and the next rate case decision. The parties also indicated that the 8.7% was solely for purposes of making those GSRS and SIP filings and was not to be considered presidential for any other purpose. Slide 11, please. Issue 4, capital structure. The parties were also unable to reach an agreement on the appropriate capital structure that should be used to set rates in this case. In the settlement, the parties therefore agreed that nothing in the settlement constituted an agreement as to the capital structure used to set rates in this case. Slide 12, please. Issue 5 relates to Atmos Energy's System Integrity Program, or SIP. Slide 12 summarizes the 3 terms agreed to by the parties relating to Atmos Energy's request to modify and extend its SIP program. First, the parties agreed that Atmos Energy should be allowed to withdraw its request to increase the budget for the remaining term of the 5-year pilot program from $35 million to $50 million. Second, the parties agreed that Atmos Energy should be allowed to withdraw without prejudice its request to extend its SIP program for additional 5-year period. And third, the parties agreed to work through the issues that were raised by the parties in this case relating to the request made by Atmos to extend the SIP program, with Atmos Energy being allowed to file a new request to extend the SIP program sometime in the future. Slide 13, please. With respect to the existing SIP program, which is now in its 3rd year of the 5-year program, the parties did agree to a few changes that are summarized on slide 13. The parties agreed.
Sorry, Mr. Flaherty, I'm not hearing you.
We can hear him.
Okay,
Can you hear me now?
yes, I can.
Okay,
Very
sorry.
good.
You want me to move back on, what was the last thing you were saying?
Let's see, slide 13, you said with respect to the existing SIP program, which is now in its 3rd year of the 5-year program.
Okay, the parties did agree to a few changes that are summarized on slide 13. The parties, and these were recommendations made by the commission staff. The parties agreed that Atmos Energy should modify its risk assessment model to place a greater weight on the risk associated with bare steel service lines. The parties memorialized their prior agreement on cost recovery relating to post-1983 plastic pipe replaced as part of bare steel replacement projects. And the parties agreed that to the extent that such information is available, that Atmos Energy shall report to the KCC any root cause analysis on leaks discovered on plastic piping. Slide 14, please. Issue 6 related to ad valorem tax expense. This is another issue where it is necessary for the parties to reach agreement on the amount of ad valorem tax expense included in base rates, because that expense must be known to set future ad valorem tax surcharges that are allowed to be collected or refunded by statute. Slide 15, please. Issue 7, the agreement sets forth the amortization periods relating to the actual rate case expense, pension and OPEB deferrals, and state and federal unprotected excess accumulated deferred income taxes. Slide 16, please. Issue 8, for purposes of calculating Atmos Energy's pension tracker going forward, the parties had to agree in the settlement what the expense amounts were for each of the items listed in slide 16. Slide 17, please. Issue 9, the parties were required to include in the settlement how revenues approved in future GSRS and SIP filings would be allocated to customer classes. That allocation is reflected in Appendix B to the settlement. Slide 18, please. Issue 10, the parties were also required to agree upon and show how the annual revenue requirement increase, in this case, the $2.2 million, would be allocated among the classes of customers, and that allocation is reflected in Appendix B to the settlement. Slide 19, please. Appendix B, page 103, which is attached to the settlement, is shown here on slide 19. If the commission recalls, during the public hearing, there were a number of customers who raised concerns about how any revenue requirement increase would be allocated between the classes of customers due to Atmos Energy's class cost of service study showing that there should be no change to the rates of customers served on the commercial sales, public authority sales, school sales, large industrial interruptible sales, and transportation customer classes. As shown in the spreadsheet on slide 19, the customer classes are set forth in column 1. If you look at the second to last column on the spreadsheet, which is labeled column F and titled class percentage increase, you can see that the revenue requirement increase in the settlement ended up being spread fairly evenly across customer classes and therefore addressed those concerns that were raised by the customers during the public hearing. Slide 20, please. Slide 20 is a copy of Appendix B, page 3 of 3, that's attached to the settlement. This spreadsheet shows the current facilities charge and commodity charge for each customer class under the column entitled current rates, and the rates that were agreed to by the parties in the settlement under the proposed rates column. Slide 21, please. Issue 11, related to Atmos Energy's efforts to update and modernize its tariffs in general terms and conditions. Staff and CURB provided comments to the changes recommended by Atmos Energy, and as part of the settlement, Atmos Energy agreed to include in its changes the recommendations made by staff witness Prentice that are laid out in his direct testimony. Atmos Energy also agreed to withdraw its request to eliminate its miscellaneous service charges. Slide 22, please. Issue 12, transportation issues. Atmos Energy proposed a number of changes to its transportation tariffs in order to address the issues that arose during Winter Storm Uri in February of 2021. The parties reached agreement on 5 changes to the transportation tariffs that should address those issues that arose during Storm Uri. Change number 1, all transportation customers will be required to install electronic flow measurement or EFM equipment by November 1st, 2024, with a few exceptions, including schools that use less than 3,000 decatherms per year. Change number 2, Atmos Energy will pay for EFM equipment for school transportation customers that use at least 3,000 decatherms per year. The cost of the equipment will be placed in a regulatory asset with a carrying cost at the approved rate of return for the GSRS and SIP investments, with that asset being recovered in the next rate case using an amortization period of 9 years. Slide 23, please. Change number 3, Atmos Energy will continue to allow transportation customers the option to pay for EFM equipment on a monthly basis, and the agreement sets forth the terms of that monthly payment. They're also spelled out on this slide 23. Change number 4, transportation customers will be required to have an Atmos Energy administered wireless communication line. And change number 5, after November 1st of 2024, in order to qualify for transportation service, new transportation customers shall have a minimum annual gas usage of either 1,500 MMBTUs in any month or 5,000 MMBTUs in a year. This excludes schools and existing transport customers. Slide 24, please. Issue 13, Atmos Energy proposed a smart choice carbon offset tariff. The parties agreed that Atmos Energy's SCCO rider should be approved as corrected in Mr. Smith's rebuttal exhibit as a 6-year pilot, with that project, that program to be reevaluated at the end of the 6-year period. Slide 25, please. Issue 14. The parties agreed that Atmos Energy should be granted a waiver from the Commission's standards pertaining to debit and credit card charges to reflect that charges relating to debit and credit card payment options have been recovered in base rates by Atmos Energy. Slide 26, please. This slide sets forth the three factors the commission considers when reviewing a proposed settlement. The joint motion that was filed by the parties addresses each of these factors from a legal perspective. Mr. Matthews applies these factors to the settlement in his testimony in support of the settlement, as does Ms. Crane and Mr. Grady, to show how the settlement meets each of these three factors. As I previously indicated, Mr. Matthews should be able to answer any questions you have relating to the settlement. Atmos Energy would like to thank all the parties for the professionalism that they showed in this case. And Atmos Energy requests that the commission find that the settlement meets each of the three factors and approve the settlement. Thank you.
Thank you, Mr. Flaherty. Next, opening statement is Wood River, Alex Goldberg.
Thank you, Madam Chair. Good morning. I represent Wood River Energy. Wood River is a natural gas marketing company with a long history of serving customers in the state of Kansas. We participated in this proceeding solely as to the transportation tariff issues. And we wanted to make just a quick statement to express our support for the settlement, and that the settlement, we do believe, has reached an equitable compromise on the transportation tariff issues for our school customers, as well as other customers, and particularly with respect to the electronic flow measurement inclusion in the settlement for customers over 3,000 MMBTUs per year of service, and for the cost recovery provisions, for the cost of installing that EFM. One important point that is in the settlement is that the settlement does require a compliance filing to be made to incorporate the tariff changes. And we look forward to working with the company, staff, and CURB, as we have over the past couple of months, to get to the settlement, to get it over the complete finish line of the submission of the compliance filing and getting the new tariff in effect. Thank you very much.
Thank you, Mr. Goldberg. CURB, I believe Joseph Apestrap. Good morning.
Yes, good morning, Chair Duffy. May it please the commission. My name is Joseph Astrab, and I represent the Citizens Utility Ratepayer Board, otherwise known as CURB. I am joined today by Consumer Counsel David Nickel and Attorney Todd Love to ask the commission to approve the unanimous settlement agreement reached in this case. CURB's role in cases before the commission is to advocate for residential and small commercial ratepayer interests. For rate cases, concerns about bill increases and improving reliability of service are front and center for CURB. We believe that the evidence in the record shows that the agreement satisfies the factors to approve unanimous settlement agreements before the commission. This agreement strikes a fair balance of ratepayer and utility interests without imposing an undue financial burden on customers. The settlement agreement represents a significant deviation from the company's filed position. CURB witnesses recommended smaller revenue requirement increases and tariff modifications through their direct testimony compared to Atmos's filed position. CURB witness Andrea Crane provides testimony in support of the agreement on behalf of CURB. She explains that the agreed upon $2.2 million revenue increase is much lower than Atmos's updated request of $7.7 million, which results in a more modest rate increase while still within the zone of reasonableness. The customer charge will increase or will be set to $19.75, well below the company's initial request, but still allowing the company to recover its fixed costs. Ms. Crane calculates that the average residential customer will experience a bill increase of 3.36%, which is just slightly below the system average increase. While no rate increases are generally welcomed, CURB views this as reasonable in light of the rises in commodity prices and labor costs. In addition to the limited revenue requirement increase, the agreement prevents bills from going up due to increases in other surcharges. Consistent with CURB testimony, Atmos agreed to withdraw its request to expand and extend the System Integrity Program, or SIP. Instead, the SIP will continue operating within the previously agreed to $35 million budget over 5 years, which is set to run through 2024. Atmos retains the ability to request an extension of the SIP, and CURB believes that it is more appropriate to bring such a request towards the end of the program rather than only halfway through. This will ensure rate stability associated with the SIP surcharge on customers' bills for the remainder of this initial term. Many of the tariff changes made through this agreement also fell in line with CURB's filed position. The agreement recommends approval of the company's implementation of a voluntary smart choice carbon offset tariff program. Under this program, customers who sign up will be able to contribute to the purchase of carbon credits to offset emissions attributable to that customer's use of natural gas for energy. The program will be self-supported by participants, and the company's shareholders retain the risk of under-collection rather than ratepayers. CURB is supportive of this new program to give interested customers an opportunity to reduce their carbon footprint through their utility bills without impacting non-participants. CURB looks forward to studying the program and reviewing the results in the future. Through this agreement, Atmos also agreed to withdraw its request to modify several miscellaneous service charges that would have been collected from all ratepayers rather than from the customers who incurred the charge in the first place. In light of treatment of credit card fees by other utilities and the fact that Atmos is not currently charging such fees, a waiver in that regard is appropriate and has been included in this settlement. CURB supports these provisions of the agreement because they ensure that ratepayers are not subsidizing certain actions or behaviors while maintaining a deterrent effect for unwanted practices. Credit card fees have been waived for other jurisdictional utilities, so CURB views the change as keeping in line with other commission orders. At the end of today's presentation of evidence, CURB and the other signatories to the agreement will ask the Commission to approve the unanimous settlement agreement as being in the public interest and meeting all the other relevant factors. Thank you.
Thank you, Mr. Astrab. And for the KCC staff, we have Tommy Connors. Good morning.
Good morning, Chair Duffy. Thanks for having me. May it please the Commission. Good morning. I am Thomas Shea Connors, appearing on behalf of the staff of the Kansas Corporation Commission. To begin, staff supports the proposed unanimous settlement agreement filed on February 21st, 2023 between staff, Atmos Energy, CURB, and Wood River Energy, LLC. As already stated this morning, Atmos filed an application seeking Commission approval to make certain changes in its rates and charges for natural gas service. For the sake of brevity, I want to elaborate on the company's original application, given that the company and other parties have already described those proposals in great detail. It is important to note that after the filing of Atmos Energy's application on January 17, 2023, staff filed its direct testimony, including schedules and exhibits supporting a recommended base rate revenue requirement increase of $5,491,831. Staff also recommended changes to the company's requested expansion of the System Integrity Program, Schedule 2 tariff changes, and Atmos's voluntary Smart Choice Carbon Offset Program. After rebasing the GSRS, the overall impact of staff's recommendations in its original testimony resulted in a net revenue requirement increase of $1,976,008. For context, CURB filed its direct testimony on the same date, recommending a net revenue increase of $1,699,914, accounting for GSRS rebasing. Both staff and CURB also addressed various tariff and rate design issues. On February 15, 2023, parties met to discuss the possibility of settlement. A settlement in principle was reached on February 15, 2023, and a final settlement agreement was filed on February 21st, 2023. As discussed, the unanimous settlement agreement established an agreed upon net revenue requirement increase of $2.2 million after the impact of a rebasing $3.5 million related to the GSRS. Additionally, parties agree that staff's recommended depreciation rates for shared services and Atmos's recommended depreciation rates for the Colorado-Kansas division be used to set depreciation rates. For the purposes of calculating Atmos's GSRS and SIP, the carrying charges to be applied to recoverable investments in such filing shall be calculated using a carrying charge of 8.7% gross of tax, which is based on the federal tax rate in effect as of the date of the unanimous settlement agreement. This carrying charge is solely for the purposes of subsequent GSRS and SIP filings and is not precedential for any other purpose. Staff agrees with the pre-tax ROR of 8.7%. The agreed pre-tax ROR is negotiated amount in the settlement agreement. Parties agree that nothing in this agreement constitutes an agreement by the parties to the capital structure proposals presented in this case, and this agreement does not prevent parties from challenging such proposals in the future. As to the SIP, parties are in agreement to allow Atmos to withdraw its request to increase the budget amount for the remaining term of the 5-year SIP pilot program from 35 million to 50 million. No changes were made to the budget or SIP program parameters. Atmos Energy shall be allowed to withdraw without prejudice its request to extend the SIP program for an additional 5-year period. The parties have agreed to collaboratively work through the issues raised by the parties in this case relating to the extension of the SIP program, with Atmos Energy being allowed to file a new request with the Commission to extend the SIP program, either in a separate application or in a subsequent general rate case filing prior to the expiration of the pilot program. Additionally, parties agreed to operational/engineering considerations with respect to the SIP program that are specifically outlined in Mr. Justin T. Grady's testimony in support of settlement and agreement, and outlined already by the company and other parties' testimony in this case. For the purpose of Atmos annual ad valorem surcharge rider, the parties agreed that ad valorem expenses embedded in base rates shall be $8,597,886. Parties agreed to certain specific amortization periods addressed in testimony. Parties also agreed to pension and OPEB expenses to be included in base rates, which is also outlined in Mr. Justin T. Grady's testimony in support of settlement and agreement. For allocating costs among customer classes in subsequent GSRS and SIP filings, parties agree that such costs shall be allocated among Atmos Energy's class of customers based on the rate allocation approved in this rate case and as reflected in Appendix B, which is attached to the unanimous settlement agreement. The parties agree the annual revenue requirement increase shall be allocated among the respective classes of customers according to Appendix B. The parties also agree to the facilities charges and commodity charges for each class as shown in Appendix B as well. Atmos Energy agrees to include in its proposed changes to its tariffs and general terms and conditions. The changes included in staff witnesses Prentice testimony, which is filed. Atmos Energy also agrees to withdraw its request to eliminate its miscellaneous service charges, which parties have already addressed today. As to the transportation tariff issues, parties have reached an agreement in which the Commission should approve Atmos Energy's request as amended by this settlement and to be captured in a compliance filing with the Commission containing revised language to require electronic flow measurement or EFM equipment for all transportation customers, except for existing smaller use meters that have been historically aggregated in order to qualify for transportation service, and school customers using less than 3,000 decatherms a year, or be converted to self-service by November 1st, 2024. Parties also agreed to other conditions regarding this issue, which have been fully set out in the unanimous settlement agreement and outlined in Mr. Justin T. Grady's testimony in support of the settlement, as well as other testimony filed in this case. In terms of the miscellaneous issues, the parties agree Atmos Energy's proposed Smart Choice Carbon Offset tariff, or the SCCO rider, as corrected and set forth in rebuttal exhibit GLS-3, should be approved by the Commission on a pilot basis. The party has agreed that a reevaluation of the program's reasonableness and effectiveness should be completed before the end of a 6-year period. The parties agree Atmos Energy shall be effectively granted a waiver from the Commission's minimum payment standards, which is important to note, pertaining to the requirement to charge a fee for customers that choose to pay their bills with a debit or credit card. At this time, staff believes that the unanimous settlement agreement is supported by substantial competent evidence in the record as a whole, results in just and reasonable rates, and is in the public interest. I'm going to briefly touch on each of these factors. The unanimous settlement agreement is supported by substantial competent evidence in the record as a whole. The agreement is supported by Atmos's application, direct and rebuttal testimony, as well as the direct testimony of several witnesses offering diverse and often conflicting perspectives about the issues presented in this case. Staff vigorously analyzed the application and formed its own conclusions that were filed in direct testimony. In addition, Curb and Wood River reviewed the filing and stated their respective positions in direct testimony. These filed positions represent the body of evidence the commission will rely on to make a determination of the issues represented in this case, if this case was fully litigated. The parties also relied on this evidence in negotiations and eventually arrived at an agreed upon resolution of all of the issues in this case. It is staff's position that the terms of this agreement are commensurate with what would be expected if this case were to be fully litigated. Mr. Justin T. Grady speaks more specifically about this in his testimony in support of the unanimous settlement agreement and is available today to address any specifics regarding the unanimous settlement agreement. Staff contends that this agreement results in rates that fall within the zone of reasonableness described by the Kansas courts. The result in this case is balance between the interests of the investors versus ratepayers, present versus future ratepayers, and is in the public interest generally. The opinion is supported by the fact that the revenue requirement is agreed to in the settlement is much closer to staff's filed position than Atmos's. Staff's direct testimony was filed with the intention of balancing all of the interests represented in this case, and the agreed upon total revenue reduction is substantial adjustment in rates from Atmos's filed position. This agreed upon revenue requirement reduction strikes a proper balance between the company's desire to have a reasonable assurance that will earn sufficient revenues and cash flows to meet its financial obligations and the need to keep rates as low as possible for customers while providing reliable natural gas distribution service. In short, the level of cost recovery afforded under this settlement reflects Atmos's cost of providing reasonably sufficient and efficient service. Simply put, a settlement that is able to satisfy each of these very diverse and competing interests is not an easy accomplishment. The fact that the parties in this case with diverse and often competing interests have found common ground for resolving their respective issues strongly supports staff's contention that the agreement in this case will result in just and reasonable rates that are in the public interest. And I'm going to touch on the last factor. Staff believes that the settlement agreement is in the public interest. There were multiple interests represented by the parties involved in these negotiations. CURB representing the interests of residential and small commercial ratepayers, Atmos representing the interests of its management and shareholders, and Wood River representing the interests of a gas marketing firm and its transportation customers. Staff was attempting to balance each of these interests while representing the interests of the public generally. The fact that these varied interests were able to collaborate and present a unanimous resolution of the issues in this case strongly indicates the public interest standard has been met. Generally speaking, the public interest is served when ratepayers are protected from unnecessarily high prices, discriminating prices, or unreliable service. More specifically, it is staff's opinion that the agreement meets the public interest because it reduces the amount of Atmos's requested revenue increase to a much closer to the staff's filed position. It provides Atmos with sufficient revenues and cash flows to meet its financial obligations to provide reliable service. It allows Atmos to continue to utilize the GSR mechanism, which has been authorized under KSA 662202 et sec, to continue replacing its aging infrastructure in the state. It provides for a path forward to address the changes requested by Atmos to its transportation tariffs requiring EFM, company administered wireless communication lines, and a larger minimum usage requirement for new transportation customers. In settlement negotiations, each of the parties represented their respective interests by putting time, thought, and professional analysis into deriving a settlement position it found reasonable. The stipulated revenue requirement increase was based on the record and is a reasonable compromise among the parties based on each party's own analysis of a reasonable outcome. And if this agreement is approved, the parties would avoid the costly and time-consuming process of fully litigating at a hearing. It is in the public interest to avoid these costs if possible, and the agreement accomplishes this result. At this time, staff respectfully requests approval of the unanimous settlement agreement for the reasons outlined here in my opening statement, and is supported in our direct testimony and our testimony in support of the unanimous settlement agreement regarding this matter. Thank you for your time.
Thank you, Mr. Connors. And I did neglect to introduce our court reporter. We have with us today Denise Haas. Thank you, Denise, for serving today as our court reporter.
Thank you.
We will follow the order of witnesses agreed to at the pre-hearing conference. Because this is a unanimous settlement, the parties have waived cross-examination, closing statements, and post-hearing briefs. So basically, commissioners, it's us. So Atmos, will you please call your first witness?
Yes, thank you, Your Honor. Atmos Energy would call William D. Matthews to stand.
Good morning.
Morning. Mr. Matthews, please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Please state your name and business address.
My name is William D. Matthews, and my address is 5420 LBJ Freeway, Suite 1600, Dallas, Texas.
Mr. Matthews, who is your employer?
Atmos Energy Corporation.
And what is your position with Atmos Energy Corporation?
Manager of Rates and Regulatory Affairs.
In that capacity, did you file testimony in support of the unanimous settlement agreement that's being presented to the commission today?
I did.
Do you have any changes or corrections to that testimony?
I do not.
If I were to ask you the questions in that testimony, would your answers be the same today?
They would.
Your Honor, I'd ask that Mr. Matthews' testimony in support of the unanimous settlement agreement be referred into the record.
Is there objection? Hearing none, it is ordered.
And I would tender Mr. Matthews for commission questions. Thank you.
Thank you, Mr. Flaherty. Good morning, Mr. Matthews. We
Good
will
morning.
start today with Commissioner King. Do you have questions of this witness?
Thank you very much. Good morning, Mr. Matthews.
Good morning, Mr. King.
I have one question for you. It's kind of a softball question, probably, but I'm really interested in the granularity of your response. As Mr. Flaherty indicated in his overview, the allocation of costs among the various customer classes is somewhat evenly and closely approximated and balanced. In your opinion, what factors played a major role in providing for this result?
That's a good question. I mean, we had quite a few different parties represented in the settlements. I feel like we reached a good agreement. We balanced the base charge that CURB was concerned with on residential customers. And I think it was based on compromise that we came up with those rates.
All right, very good. No further questions. Thank you.
Thank you, Commissioner King. I turn now to Commissioner French.
Thank you. Well, it's a little difficult to come up with a big question when we've got a unanimous settlement and some of the issues have been withdrawn. One of those issues in particular that I was interested in, probably the issue I was most interested in before you all reached settlement, was the request to increase the SIP budget from the 35 to the 50 million. That's clearly an issue that catches people's attention, especially at a time when we have more volatile natural gas prices than we did when the SIP was initially put into place. But I was glad to see an agreement on that. I guess my question, though, I'm looking at paragraph 14 of the settlement, and it just generically describes that there will be a sort of a collaborative process for the parties to work through issues. If you could just tell me in your mind, how soon do you see that process taking place, and do you view that as addressing the issues substantively, or is it more of a process collaboration where you're deciding how you will make a filing and when you will make a filing?
So this is specifically related to the SIP.
Yes.
In that extension. Yeah, I think we'd like to get started right away now that we've had conversations between all parties. I think we've already made some good headway on some compromises that we made, some changes that we're going to make to how we prioritize our projects. So I think that we'd like to get together as soon as possible and make those changes. I think we may have already agreed to, before we make our next filing, that we would get together and come up with those terms. And then obviously we only have 2 more years before we would file for an extension, either within the next case or outside of it. So it'd be our desire to work on it right away.
Okay. Let me ask one more small question. I'm looking at, well, it's paragraph 22E of the settlement, but I don't know that you need to go there. This is the piece that sets minimum gas usage limits for people to become transportation customers. And I know if I went back and dig through the direct testimony, I know I could find it. You've set those at 1,500 MMBTU for a month, any month, or 5,000 MMBTU for a year. How do those relate to previous thresholds to become natural gas or transportation customers on your system?
I don't want to misspeak, but to my knowledge, I don't know that we had a minimum threshold for transportation customers in the past.
So that leads into my next question, which is, could you just give a little more in this public forum on, what Atmos's belief for the need to set those minimums was and what prompted those?
I could speak a little bit to that. I know that there were issues during the winter storm and during peak usage times where it's tough to have a feel on the daily or the hourly use of some of our customers. So having smaller transportation customers that can switch between a sales or a transportation customer on a month-to-month basis complicates that issue. So most of these changes were to address those issues and to just tighten up our ability to be able to have some transparency on at least a daily basis of what those customers are using.
Yeah, my recollection is there were some smaller customers during Winter Storm Uri that got very exposed to the market, and I think there's some question of whether it's prudent for them to be transportation customers. Is that sort of what you're talking about?
I'm not 100% aware of those situations, but I could see that happening. Yeah.
Well, thank you. I think that's all I have. I do appreciate your testimony today, and I think I'll turn it back to the chair.
Thank you, Commissioner French. Good morning, Mr. Matthews. I do have some questions, and I put them in the category of irritating questions. So let's start off with, you don't come before us very often, but when you do, I notice that our staff's testimony spends quite a bit of time pulling out items for notice: membership dues, lobbying fees, advocacy fees, promotions, media, commercials, or whatever that you're running. Why do you continue to include those in your proposal when it appears in every utility we deal with, we pull those out?
That's a good question, and I would agree that we don't come before you often. I think we did our best to look at the settlement that we had in the last case, but in a lot of cases, some of those advertisings, we're strong believers in affordable natural gas, that it benefits our customers, and in a lot of cases, that is part of our business to promote that. So,
but all right, let me just ask you right there on that point. But I believe we're pretty clear as the commission in past rulings what we accept and what we don't. So why do they continue to be built in?
That's a good question. I think we still, I don't know if these issues have been fully litigated or or if these are items that we have settled to in the past explicitly. But I'd have to look into that.
Okay, I think that falls under do better next time. And I'd share that for every utility. Also, in particular, I do notice that the postcard for public comment notice, the bill was approximately $11,900. Hot dog. I found that surprising. Let's put it that way. To send that to your customers, a postcard, which is a reduced rate, and essentially maybe you could take the last one and change the docket number, update the dates. I mean, we're not designing a brochure for travel to the Bahamas. I guess you don't need to answer that. I just found that surprising.
Okay.
Disappointing, maybe that's something in-house that can be done. Okay, let me turn you to another area. I read through Leo Hanos's direct testimony, and on page 6, at the bottom of the page, the question is, what is your opinion about Atmos replacement rate of bare steel service lines? And the lines go directly to the house, from the pipe to the house. And the rate, Mr. Hanos replies, I believe this rate of replacement is unacceptable. And service lines are defined, and he goes on and talks about the definition, and that I think he said 80% of the hazardous leaks caused by corrosion that you found on your system were discovered on service lines. So with this settlement before us, what is Atmos' plan going forward?
I think what we agreed to there was that we were going to adjust how we rank our projects, that we were going to put a high priority on those service lines, even more so than we had in the past.
Okay. Is this common in other jurisdictions that Atmos is located in, that these service lines are a problem?
I'm not aware of that.
Okay. All right.
I definitely look into it.
All right. Then we talk about the, or Leo Hanos talks on page 10, at the bottom of page, line 17, has the Atmos pipe replacement plan demonstrated a reduction in risk? He states Atmos appears to be making progress in reducing its leak on bare steel. That's good to hear. So what do you believe that's as a result of?
I'm sorry, could you repeat that question for me?
Well, the fact that there's been a reduction on leaks related to bare steel, why is that occurring? That's a good thing. Is it because of your replacement program, or?
I would have to speculate, but I would say that it is because of our replacement program. I know that we've ranked these projects and are going after those that have the most leaks or have the highest consequence areas first.
Okay.
I
Yeah, I would
could go
hope
back to
so.
our engineering department and get a better answer for you, though.
Well, further on page 12, line 11, the question is, does Atmos have an adequate pipe replacement prioritization methodology? And Mr. Hanos responds, Atmos's prioritization scheme appears to be adequate. Adequate to me is like my mother-in-law's cooking was adequate. It fed our body, but it didn't taste very good. He argues the safety risk could be lowered if there was more focus on replacing bare steel service lines. So I don't need you to go back to your engineers. My observation is this is your business, day in and day out, providing gas in a safe way to all customers. And this bare steel continues to be a problem in Kansas. I guess my comment would be, as you go forward with your programs and your prioritization, that you are taking Leo Haynes's testimony to heart. Okay, let's go to another irritating issue. Debit cards and credit cards. Very simply, under this settlement agreement, what will the waiver allow Atmos to do?
There will actually be no change to what we're doing. I think we filed at least our last 3 cases this same way. I think this addresses language that was in our tariff that gave us the right to charge up to a certain fee for customers that use debit and credit cards. And it comes from a time when there was very low customer participation. And so it didn't make sense to charge 100% of our residential customers a fee that was incurred because of a small percentage. When credit card and debit card fee usage dropped significantly, and we had much higher adoption for the last 10 plus years, those costs have been spread across all customers. So that we're proposing no change. I think that this is just to formalize that waiver.
So the costs would continue to be socialized.
That's correct.
What is your average residential customer, about what is the cost of that credit card each month when they use a credit card, not a debit card, but a credit card?
I know I can get that information broken out, and I know that we had a discovery question related to that. It seemed like the fee that I saw, and I hate to speculate, was somewhere around 40 cents per transaction. But I do not know if that was debit and credit card both. But we could break that information out as much as we can.
Okay, but I would agree with there was some testimony surrounding this by several witnesses that this is an area that needs to be studied. I still have a checkbook, and I send my checks in. The one time I didn't to one of my utilities, I was dinged with a $4 charge for the privilege of using a credit card. After that, I made sure I was writing the check, knowing that, and putting it in snail mail, knowing that snail mail now I should add on 2 or 3 extra days, but that's my problem, not anybody else's. Okay, let me ask you this, Mr. Matthews. How many issues in the settlement do you believe were a direct result of Storm Uri? And if you could even, like, just very quickly share which issues those were.
Let me locate that list real quick. So the question is, how many of these 14 items that we settled on were these items became a settlement item because of Winter Storm Uri?
Well, they're settled, but either you included them in your filing, but they come about because of Storm Uri. For example, the transportation change, is that because of Storm Uri?
I believe pretty much all of those transportation tariff changes came up because of that one issue. Yes.
the wireless connection that's going, is that like, so you can communicate via a phone call or text? Is that what that's about?
I believe it has to do with how the electronic equipment communicates reading back to us. I'm
Okay,
not 100%
all right, so
certain
it's
on that,
really,
but I do remember those discussions, yes.
okay, so it's really about the technology that's being used on the electronic flow monitors.
I believe so, and the remote location of some of our customers, I believe.
Okay, and again, remind me, how many customers do you serve in the state of Kansas?
Let me refer to Appendix B to the settlement that has the rate design. I get about 138,000 sales and transportation customers.
Okay, and I noticed in the testimony where it appears your rate of increase for residential customers has increased over the last couple of years. What is that a result of?
The rate has increased.
No, the number of customers has increased.
I assume that we're just adding new customers in new areas, that we've got growth in the state. As I recall, maybe a little less than 1% is what I've seen as customer growth in the state.
Yeah. Okay, very good. Okay, Mr. Matthews, those are all the questions from me. Thank you for your time.
Thank you.
You may virtually step down.
Your Honor, could I just ask a
Oh,
couple?
I'm so sorry. Redirect, Atmos. I'm sorry. I
Thank you, Your Honor.
apologize.
Thanks. Mr. Massey, did you recall the questions that Chair Duffy asked you with respect to Mr. Haynes's testimony and the recommendations he made with respect to the current SIP program?
I do.
And is it your understanding that those recommendations that Mr. Haynes made are included in the settlement that is in front of the commission today?
I believe they are.
That's all I have. Thank you.
Thank you, Mr. Flaherty. And so Commissioner Keen, I see that you are not on mute anymore. I'm sorry. Did you want to ask another question?
No, thank you.
Oh, okay. All right. I just wanted to make sure. And I didn't ask Commissioner French. I apologize. So it appears he doesn't have a question. Okay, thank you. And again, Mr. Matthews, you may virtually step down. I appreciate your testimony today.
Thank you.
Herb, you may call your witness.
Thank you. This is Todd Love, and I will be introducing Andrea Crane. Andrea, are you on the call?
I am.
Yeah. Could you please state your name and business address for the commission?
Mr. Love, would you like me to swear the witness?
Oh, I'm sorry. Got ahead of myself.
You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Okay, and I guess I'll start over. Could you just please state your name and business address for the commission?
Sure. My name is Andrea, middle initial C, Crane, C-R-A-N-E. My business address is 2805 East Oakland Park Boulevard, Suite 401, Fort Lauderdale, Florida.
By whom and in what capacity are you employed?
I'm president of the Columbia Group.
Are you the same Andrea Crane that caused to be filed 25 pages of direct testimony on January 17th of 2023? Also a errata filed on January 19th of 2023 and testimony in support of the unanimous settlement agreement filed February 24th of 2023?
Yes.
Do you have any changes you'd like to make to that testimony?
No, other than, as you pointed out, we did file an errata to the schedules. The numbers that were originally filed were right, but there were some formatting errors and errors in the sources that we corrected through the errata.
Thank you. If I were to ask you the same questions today, would your answers be the same or substantially similar?
Yes, they would.
At this point, Commission, I would like to tender Ms. Crane for the Commission's questions.
Thank you. I appreciate that, Mr. Love. And we will turn to our commissioners, and I will begin with Commissioner Keen.
Thank you very much. I've read through your pre-filed testimony, Andrea. I thought it was quite good. I have no questions of this witness.
Thank you.
Thank you, Commissioner
Okay.
Keen.
Thank
And
you.
turning to Commissioner French.
Thanks. Just briefly. Hi, Andrea.
Good morning.
I wanted to address the SIP component of the settlement with you as well, because I know that was an important piece to curb. And I do know that that was something I believe Mr. France addressed primarily. So it's okay if you need to just defer or say that it's not a question for you. But your understanding of the settlement is that by withdrawing the request to increase the budget of the SIP program and the extension, Atmos will just continue on for the remainder of the initial term at the original or the existing budgetary level. That's your understanding?
That's correct. Although they do have the right, presumably, to file something before the current term would expire. As I think has been mentioned, the current term is due to expire in 2 years anyway. So presumably something would be filed either within the next 2 years or in the next rate case, whenever that may be. But I would anticipate that they would file something prior to the expiration of that 2-year period. So they do have the right to continue discussions and perhaps to make a filing within the next 2 years.
It's probably a better question for the Atmos witness, but the expectation would probably be that they would try to line up these discussions and have a filing ready so they could probably have some sort of seamless transition between the existing SIP and whatever new proposal they intend to have. Is that a fair expectation?
Yeah, that would be my expectation.
And I mean, I know I raised the issue of, budget levels and, customer concerns related to that. Do you expect that will be part of the discussion? Or do you expect the discussion, this collaboration, to be more of a process discussion? Or do you think it may be more open-ended to discuss any concerns the parties may have?
I would expect it to be more substantive and at least to attempt to reach some agreements with regard to levels and maybe specific programs. I don't know whether that will happen or not, but I would expect that at least those discussions would be held to see if we could reach a consensus.
Okay. Well, I think that's all I have, Ms. Crane. I appreciate your perspective and thank you for your testimony.
Thank you.
Thank you, Commissioner French. Good morning, Ms. Crane.
Good morning.
Following up on Commissioner French's line of questioning about the SIP and the ability to hopefully reach consensus in the future, like on a scale of 1 to 10, is that going to be a real heavy lift, or do you think that's something that can be arrived at with, there was time constraints on reaching a settlement, but past that, do you think that will be something that can be done fairly easily?
Well, I think there's really two issues. I mean, one issue I think that Curbs struggled with a little bit is now the time to make a change to the current program. We're sort of in the middle of a new program that was authorized for a 5-year period. And maybe we should, I think from Curb's perspective, one of the issues was perhaps we should wait let's call it another year, or until we're a little bit even further into this 5-year period before we begin to discuss the extension or the expansion of that program. So that's sort of a policy issue that I think we have to decide when is the timing right. But once we kind of make that decision, I would expect that the parties would be able to reach a resolution on the dollar amount. I mean, I think we have a history with Atmos of having some successful, discussions and being able to reach agreement. And I would hope that we would be able to reach an agreement on the expansion and the extension of the SIP as well. I mean, it's not really my area of expertise, the engineering aspect. So I can't say for sure. I will certainly be mostly concerned about the rate impact because that's the area that I generally am most involved with. But just given the history of settlements with Atmos, I would hope that we would be able to reach agreement whenever we feel that the time is right to, to introduce or to extend the program.
Okay, thank you. Concerning the carbon offset program and a 6-year pilot, from CURB's perspective, is 6 years? I mean, that sounds like a long pilot. And based on your experience, maybe it needs to be 6 years?
Well, I believe the CURB recommended a 5-year pilot program. Again, that was not in my testimony, so I could be mistaken on that, but that's my recollection. I know the important point to CURB was that it be introduced as a pilot. I think CURB was less concerned about the specific number of years for a pilot program. I think CURB was more concerned about the sort of philosophical argument of, introducing new programs on a pilot basis. And I think that was an important precedent for CURB. So the company obviously had discussions with CURB, and in the spirit of settlement, CURB got its pilot program, and the company got an extra year to offer the initial program. So I think we were both happy. But it was really the pilot aspect that I think was most important to CURB.
And are you familiar with these carbon offset programs and other jurisdictions?
Not really. I mean, I haven't personally been involved with such programs in other jurisdictions.
Okay. I'm going to turn to testimony offered by Josh France. I'm on page 33 of his direct testimony, and actually, he's pretty eloquent here. It's relating to socialization of credit card fees. He says, I certainly acknowledge that it has become irregular for customers to be charged for the usage of credit cards in general commercial transactions. However, monopolistic public utilities who offer an essential service to a captive customer base operate under much different pricing conditions than retailers in a competitive market. Structuring pricing based on the cost causation principle is much less straightforward in the free market, where competitive pricing is paramount. He also references problematic debt, that the usage of credit cards is one aspect of folks going into debt. Can you, let me put it this way. We haven't changed our policies on this since 2005. Can you offer a little bit of color around this issue?
Yeah, I mean, this is in some ways a difficult issue because I can really see both sides of the coin here. I mean, credit cards are an easy way for people to pay their bills. It can be a good way to reduce uncollectibles for a utility company, which benefits all customers. On the other hand, credit card payments are generally pretty expensive. So it comes down to who's going to pay the bill. Is it going to be paid by the individual who's using their credit card, or is it going to be paid? Is it going to be paid by the overall body of ratepayers? And, I've actually argued in certain cases in the past that it should not be socialized, that customers should be required to pay those costs themselves for using their card. I mean, some people use their card just because they want the airline miles or something like that. There are many reasons why people use credit cards. I've been guilty of that myself. So, however, over the past few years, I think the policy has been more and more towards socializing those costs among utility companies. And I think it's become more common for utility companies to have the general body of customers absorb those costs. In this particular case, it's my understanding that the tariff permitted Atmos to charge, but did not require the company to charge. And in fact, they weren't actually charging those customers. So in order to implement a new charge on Atmos's customers, may have been viewed as punitive. So in this particular case, I think it made a lot of sense to continue with the current policy and to just sort of acknowledge that those costs are and will be in the future socialized. But I guess personally, I'm torn a little bit about subsidizing customers, who choose to pay their bills by credit card in order to get airline miles. That other customers should be forced to pay for that. But there are certainly benefits to socializing that and to increasing the number of the amount of revenue that can be collected, sometimes only through credit card payments.
Okay, thank you. I will go back to the commissioners. Were there any additional questions or comments that you wanted to make? Commissioner Keen? No? Commissioner French? Okay. Curb, redirect. Mr. Love?
I have no further questions for Ms. Crane.
Thank you, Mr. Love. Ms. Crane, you may virtually step down, and thank you for your testimony today.
Okay, thank you.
Staff, if you could call your witness.
We would call Justin Grady at this time.
Mr. Grady, please raise your right hand. You do solemnly swear the testimony you're about to give in the matter non hearing will be the truth, the whole truth, and nothing but the truth, so help you God. I'm not hearing Mr. Grady.
Uh-oh, I do.
Okay, thank you. I can hear you now.
Thank you.
Mr. Grady, would you state your name for the record, please?
Yeah, my name is Justin T. Grady.
By whom are you employed?
I'm employed by the Kansas Corporation Commission.
And in what capacity?
I am the Chief of Revenue Requirements, Cost of Service, and Finance in the Utilities Division.
In that capacity, have you caused to be prepared testimony in support of the settlement agreement dated February 24th, 2023?
Yes.
If I were to ask you the same questions that are contained in your testimony, would your answers be the same?
Yes.
Do you have any changes or corrections to that testimony?
Not that I'm aware of.
Your Honor, at this point in time, I would ask that Mr. Grady's testimony be admitted into the record and spread upon the record as well. Thanks.
Is there any objection? Hearing none, it's so ordered. Thank you.
And I would tender Mr. Grady for cross-examination.
Very good. Good morning, Mr. Grady. We are going to start with Commissioner Keen. Commissioner Keen, please.
Good morning, Justin.
Good morning.
I have two questions for you. In both instances, I want to use Mr. Flaherty's what I thought was a well-presented overview as a reference point. My first question is, and it's very open-ended here. It does dovetail to a certain extent with the questions that were asked of previous witnesses by Commissioner French. But my question is this: from among the few factors that Mr. Flaherty indicated the parties did not reach final agreement on in this settlement agreement, are there any of these unresolved or outstanding factors, in your opinion, that are time sensitive for future consideration or resolution?
So you broke up just slightly there. Did I hear you say, are they time sensitive or?
My question was, are any of these, can you hear me now?
Yeah, you just broke up for a slight second. I just couldn't hear when you said time sensitive or critical. Was that the question?
Crime, time sensitive for future consideration and resolution.
Oh, okay. Well, not overwhelmingly, right? Not extensively time sensitive. You know, the biggest issue I would say that remains amongst the parties is and will be the parameters around which the system integrity plan tariff can continue after 2025, right? You know, and that's mostly the financial revenue requirement, financial construction components of the tariff, as opposed to the engineering components of the tariff. You know, the settlement contained the operational and engineering revisions that staff recommended. But, you know, I guess primarily because CURB and Atmos had a difference of opinion from staff with regard to, you know, the need to make the changes that I recommended, the financial changes that I recommended to the SIP tariff. We just couldn't get in it. We just couldn't come to an agreement on those elements of basically of my testimony. And so it's not necessarily time sensitive because they are operating under a tariff that expires at the end of 2025. But my sense is that, well, first of all, they have to seek an extension or a revision filing before December 31st, 2024. And, you know, given the amount of work that they have to do on that system, I don't think they want to allow that system integrity plan to lapse. So, you know, I guess ultimately what I became comfortable with is the fact that, you know, it's not like this is an issue that's not going to raise its head again relatively soon. In other words, I mean, I wouldn't be surprised if, you know, definitely before the end of the year, they approach us to start these conversations. And, you know, they're going to be back before us having a substantive conversation about the parameters of the SIP tariff, you know, before we know it, basically. So I don't know if that's, you know, time sensitive, but it will be. I'm sure it'll be here before we know it.
I appreciate the answer. I was looking prospectively, and that's the way you answered it. I thank you for that. My other question, again, using Mr. Flaherty's overview as a reference point, same question I asked of Mr. Matthews. I would ask of you, Justin, and that is the allocation of costs among the various customer classes here appears to be somewhat evenly and approximately balanced. What factors, in your judgment, played a major role in providing this result?
Yeah, so you know, each of the three major parties in this proceeding, right? I don't mean to belittle Wood River's intervention and participation in the proceeding, but I should say the parties that had a revenue requirement and a class cost of service view, each of the major parties in this case performed a class cost of service evaluation in a study, right? And that class cost of service evaluation and, you know, and the multitude or the spectrum of views that are presented within those studies in terms of whether classes are currently paying, are currently contributing to their allocated costs of being provided service. It's that analytical framework that underpins the negotiations that go into the distribution of costs amongst the classes, and then ultimately the calculation of the rates. And, I think fortunately, the analysts in this case, whether it be Atmos's class cost of service analyst or Curb's or staffs, all have experience and previous exposure to the other witnesses and understand their positions, and there's a lot of mutual respect that goes on. So, ultimately, there's quite a bit of substantive dialogue that goes into differences of opinion about class cost of service, assumptions or methodologies, and then people have firmly held views. Curb, it's not a secret. I think Curb mentions it quite frequently in public forums and at the public hearing. Something that they care a lot about is minimizing to the greatest extent possible the minimum monthly customer service charge. The minimum customer charge is a major policy goal of theirs. And so, sometimes in those negotiations, there are sort of firm lines that are drawn or objectives. And once you arrive at whatever that customer charge is going to be, then to a certain extent, it just becomes math in determining what the volumetric charges are going to be. And then you need to, take into account the various class cost of service studies that have been done to make sure that at the end of the day, the resulting distribution amongst the classes is supported by the record, by the evidence that's been put into the record via the class cost of service studies. That's all maybe a little bit too generalized, but that's the way it's done. That's what contributed to the specific numbers that are in the Appendix B.
Thank you for the response. I appreciate it very much. No further questions of this witness. Thank you.
Thank you.
Thank you, Commissioner Keen. Commissioner French.
Thank you for your testimony, Mr. Grady. I don't believe I have any questions for you. Thank you.
Thank you, Commissioner French. Good morning, Justin. I do want to follow up on Commissioner Keen's line of questioning. How long is this class cost of service evaluation that everyone did? How long are they good for?
It's based on the test year.
Right.
And it's based on the adjustments to the test year. So
each time do you move that? Every time this comes up with a particular utility, you're adjusting it for the test year, correct? And this one ended on sometime in 2022. Is that right?
Yes. So you definitely want to perform a class cost of service study every time you change base rates. So if this company were to file another rate case in say 3 years or 2 years, we would perform another class cost of service study. There are some surcharges and some tariffs that contain a sort of an outer limit of like around 5 years. I think that's sort of well accepted that if you haven't performed an analysis of how your customer class costs might have shifted within the last 5 years, it's probably time to do that. So I think there are even some requirements explicitly in commission tariffs. The transmission delivery charge is one that I'm thinking about for Evergy Kansas Central that says, at a minimum of once every 5 years, we need to reevaluate the class cost relationship that's occurring.
Okay, very good. And those, it requires a lot of effort and work. And like you said, everyone does have respect for the other's work that is done. But I guess I don't understand then why the company submitted their proposal as they did if that class cost of service really kind of leads you to the cost between the customers.
Well, the company's class cost of service differed quite significantly from staff's recommendation, which shared, quite a few differences between CURB's recommendations. So it's, if we were, to have litigated this case, or if we had their class cost of service witness on the witness stand, he'd probably tell you definitively why we're wrong, right? And why CURB is wrong and why they are right, and why, that wasn't just a random or an arbitrary rate design recommendation by the company. They believe strongly that residential customers, or at least in their direct testimony, the residential customers needed to basically take the increase in order to in order to properly align residential customers with the cost of providing them that service.
Okay, thank you. As it relates to the SIP, is there anything coming down from the feds that would alter the discussion we will be having? Are there any requirements or anything out there, basically, I guess, because of Storm Uri, that would impact our discussion with the company?
Not that I'm aware of. I mean, Leo obviously, lives and breathes that sort of knowledge, and whether or not there are federal regulatory requirements from a pipeline safety perspective is definitely outside of my shop or my expertise. Specifically with regard to Winter Storm Uri, in response to one of your earlier questions, all of the requirements for electronic flow measurement, the requirement for new transportation customers to be above a certain size threshold, all of those changes, with exception of maybe the requirement for a company administered wireless phone plan, I would say that, absent Winter Storm Uri, we probably wouldn't have made any of those changes.
Were there any other changes as a result of Storm Uri that we need to address with this company?
No, not that I know of. I mean, we have made, each of the gas utilities has made significant progress and changes with regard to their gas purchase plans and their hedging plans and their hedging strategies, to do what we can to prevent, the financial ramifications of another Winter Storm Uri. And Atmos is no different in that regard. Actually, we have a gas purchasing and hedging plan meeting coming up with the company within the next few weeks. We met with them 2 weeks ago. We're almost in constant communication with these companies nowadays, to try to stay on top of the changing market dynamics and the much more volatile natural gas market than, Winter Storm Uri permanently from February 19th through today has changed the natural gas market in Kansas and nationally in a lot of different ways. And so, we're constantly doing what we can to stay on top of that and making those changes. But otherwise, no, the transportation issues, the transportation tariff issues, electronic flow measurement, we're working through each of those issues with each of the three utilities, either in, a general proceeding or in a rate case as it comes up. And these were the priority issues that we needed to work through with Atmos.
Then, Mr. Grady, you mentioned some other issues that you're still talking about with gas companies as a direct result of Storm Uri. Will you be coming back to the commission with some recommendations for us to adopt that would affect all of the gas companies in this state, or are we going to be taking them up company by company?
So we have been taking them up company by company. You know, my understanding is that, for instance, KGS will be filing a new application addressing transportation tariff and customer issues this spring yet. As you know, we just had a rate case with Black Hills and we made some changes on their transportation tariffs. And so we've made changes to the hedging budgets and the hedging plans, which have come before the commission or been filed in compliance filings before the commission. So yeah, so it's all of that is and has been proceeding on a company by company basis.
Okay, very good. All right. Let me look here at my notes. Oh, just briefly on the carbon offset program and the 6-year pilot. Is this new for a gas company in the state of Kansas to have in place?
The carbon offset program or
Yes.
So Black Hills just had a similar, not an exactly the same program, but a similar program approved by the commission. I do a very poor job of judging historical time periods anymore, but I mean, within the last 12 months, I'm almost certain the commission approved a similar program for Black Hills. It was a pilot program. So our review in this case was very much predicated on comparing Atmos's proposed program back to Black Hills because we had already reviewed it. You know, the recommendation for it to be a 6-year pilot is kind of funny. I mean, we didn't have a recommendation for it to be a pilot in part because we were you know, we recommended approval of Black Hills, and I guess we kind of gotten more comfortable with the concept. You know, it's a voluntary program. It doesn't harm. It's set up to be totally insulated from other non-participating customers. And so, you know, for a regulated utility, when the regulated utility is offering its customers more choice and more voluntary options, it's difficult to find reasons to say no to that. But CURB filed testimony and felt strongly that it should be a pilot. You know, on the other hand, the company's view was we're doing this in a lot of our other jurisdictions and it's not a pilot there. And so the 6 years was just purely a negotiated term that made the company comfortable with the settlement and made CURB comfortable with the settlement. And we were sort of indifferent with regard to the time period on the pilot. I think it also, you know, might have considered from the company's perspective the fact that they're a multi-jurisdictional utility with a bunch of these programs going on in different states. And so I think there was a timing, you know, to do it on a 6-year pilot instead of a 5.
But I believe the way the settlement is worded that this could be reviewed at an earlier date if the parties agree.
Yeah, I don't recall that, but I wouldn't be, you know, I think that's fine. You know, we just, if this was the very first time we'd seen it in Kansas, then we probably would have been more forceful in advocating that it be a pilot. I think CURB's view is not an unreasonable one. They're saying, hey, this is the first time that Atmos has done it, so every company should have a pilot, you know, and so I understand. I mean, it's not an unreasonable position.
Okay, all right, very good. Thank you, Mr. Grady. I'm going to turn back to Commissioner Keen. Is there any follow-up? No. And Commissioner French? No follow-up there. Thank you, Mr. Grady. You may virtually, or staff, I'm sorry, redirect Mr. Hendricks.
You probably anticipated what I would do. I have no further questions. Thank you.
Okay, very good. Okay, Mr. Grady, you may virtually step down, and thank you for your time today.
Thank you.
This now concludes our hearing in docket number 23 ATMG.
Chair Duffy?
Oh, yes.
Yeah, I had two other matters I'd like to just bring up briefly with you.
Oh,
if that's okay.
sure. Go ahead.
Okay. So the first one was we were able to track down the answer to your question regarding the postcard information. So the postcard was designed in-house by Atmos Energy, so there was no charges relating to the design in the rate case expense. I think the number the item you were referring to is in the rate case expense exhibit, line 10, the JA Design Solutions, and the cost was $11,394. From what Atmos Energy tells me, that was what it cost to actually print out the postcards. So the 138,000 postcards cost that amount. And then the mailing out of those postcards, in addition to, this was the second notice that went out to the customers, and it was in lieu of the $30,000 to $40,000 we usually pay on newspaper publications.
Sure.
The mailing of that postcard is included in the overall cost of mailing relating to the issuance of those postcards. But again, based on my earlier comments, still think that was better than spending the money and putting the notice in newspapers across Kansas. So the second item I had was, right now the commission's set to issue an order on May 9th. If there's any way, so we don't have to prorate the bill, for the commission to issue an order so that the new rates would go into effect on May 1st. And I don't think any of the other parties had any objection to that. We would ask the commission to at least consider doing that so that the new rates would go into effect at the beginning of the month. Thank you.
Okay, thank you. Must be some heavy duty card stock that was used. Okay, thank you, Mr. Flaherty. All right. Okay, I believe, and I'm looking around, I don't see anybody's speaker on. Okay, this concludes our hearing in docket number 23 ATMG 359 RTS. As a reminder, the parties have waived post-hearing briefs, so the remainder of the procedural schedule is as follows. March 10th at 5 p.m., public comment period ends. And my understanding is, as was stated previously, there's been quite a bit. March 20th, PACP does report on public comments, and that will be submitted to the commission and to everyone. April 3rd, the amicus brief is due. And again, May 9th is the commission order due date, but noting Mr. Flaherty's comment. Thank you. Video of this hearing is available on the commission's YouTube channel, which can be accessed through a link on the commission's homepage. If there are no further matters, and I'm looking around again, we will close the record and adjourn. Thank you, everyone. Have a good day, the rest of the day. Thank you.
Thank you.